So welcome to second part of our discussion of constitutionalism in our constitutional law class. What Madison is quoted to have said still resonates very well anytime we are discussing this subject, that if men were angels, no government would be necessary. Now that simple sentence, which we have explained before, is quite profound, and at the very least, it reminds us that uh, human beings, we have the propensity to have our way, propensity to overstep, propensity to explore. And that also applies when we're endowed with the power of governance or the authority to rule others. And that is why constitutionalism teaches us that there's a need for some restraint to be put on the wheels of governance so that those in charge of governance will not arbitrarily interfere or violate the rights and freedoms of the governed. So we have been looking at the underlying philosophy of this important concept of constitutionalism in constitutional law. So tonight, we want to continue with our discussion by trying to situate that within the context of our current constitutional dispensation. But we have already noted that if you look at the period immediately after independence in Ghana, the independence constitution, so to speak, provided significant safeguards for ensuring what we call limited government or a restraint on government. That notwithstanding, we saw how in the course of time, we abandoned the independence constitution. We had our Republican experience by adopting the 1960 Constitution. And if you look at the 1960 Constitution, by which time we had severed our political umbilical cord from the metropolitan ruler, that is the colonizer. Now, that constitution, as we have noted, gave sweeping powers to parliament, especially when it came to matters which would enable African unity, something which our first president, Dr. Kwame Nkrumah, was so passionate about, to be attained. Parliament could virtually do anything, including surrendering our very power to govern ourselves as in sovereignty. And again, if you look at the Constitution, so much power was given to the president at the time, as we discussed in our previous class, that he could do so many things using a broad sweep of discretion without being accountable to anyone, so to speak. And if you look at Article 12 of the 1960 Constitution, you will notice that the president was, among other things, required to take an oath at the inception of his reign or upon when he's being ushered into office. And Article 13 also required the president to make solemn declaration. And the solemn declaration had some equivalences with what we call the Magna Carta of Great Britain, by which the president gave certain assurances, certain guarantees that I will do this, I'll respect this, your freedom, I'll do this, I'll do that, I'll do that. But these were solemn declarations which were made by the president upon assuming office. Again, under the 1960 Constitution, the president could, at will, dissolve the National Assembly. The National Assembly was the parliament. The president could dissolve it at will. So, for example, if you look at the current happenings in our parliament now, that will have probably provided a good excuse for the president under the 1960 Constitution to dissolve it, so to speak. And again, the Auditor General is very important, as you appreciate now, because it's that functionary which exercises oversight over how state money is spent, how state resources are used by various public offices, agencies, and authorities. Now, under the 1960 Constitution, if Parliament could mobilize two-thirds majority, they could remove the Auditor General from office. Again, the Chief Justice was appointed from one of the judges, and the president has the power to revoke the appointment of the Chief Justice at any time. And if you go into the history, you notice how Chief Sir Akoto, for example, the first Ghanaian Chief Justice, was at one time sacked by the president, as it were. Now, when it came to promotion of public officers, that power was also vested in the president. Now, in 1964, there was a significant constitutional development, which was that the Constitution, the 1960 Constitution, was amended. And by that amendment, Ghana was turned into a one-party state. So the party of the president at the time, Convention People's Party, CPP, was declared as the national party of Ghana. And it was supposed to be the vanguard of the people, the protector of the interests and well-being of the people. Yeah, so these are some of the unique things which the president could do. He could also even issue directives through legislative instrument. The president could alter any existing legislation just by passing instrument as a stroke, and that could be done. So it was against the backdrop of all this that a legislation which was known as the Preventive Detention Act, which had been passed in 1958 and strengthened by various amendments under the 1960 Constitution. The president made orders for the arrest and detention of the senior linguist of Asantehene, known as Ochiame Bafo Akoto, and 7 others. Now, under the law, they could be arrested and detained for 5 years without any trial, without providing any justification, so to speak, so long as it was considered as being in the interest of security. So, Bafo Akoto and his compatriots who had been arrested and detained through Dr. J.B. Dankwa made an application using the prerogative right of habeas corpus sub judicendum, saying that, yes, the High Court should order the authorities that had arrested and detained Bafo Akoto and the rest to be produced and show cause or provide explanation as to why they should not be released as a free people, as it were. Now, that application was refused, and being dissatisfied with the refusal of the habeas corpus, the appellants appealed to the Supreme Court at the time. And the Supreme Court one of the grounds canvassed to bolster the appeal went as follows, and I quote as captured in the head note, the report, that the Preventive Detention Act 1958, which was not passed upon a declaration of emergency or as a restriction necessary for preserving public order, morality, or health, but which nevertheless placed a penal enactment in the hands of the president to discriminate against Ghanaians, namely to arrest and detain any Ghanaian and to imprison him for at least 5 years and thus deprive him of his freedom of speech or of the right to move and assemble without hindrance or of the right of access to the courts of law, constitutes a direct violation of the Constitution of the Republic of Ghana and is wholly invalid and void. So this was one of the grounds which was canvassed in support of the appeal against the decision of the High Court not to grant habeas corpus. Another ground was to the effect that the Preventive Detention Act 1958, by virtue of which the appellants were detained, is in excess of the powers conferred on Parliament by the Constitution of the Republic of Ghana. With respect to Article 13, Clause 1 of the Constitution, or is contrary to the solemn declaration of the fundamental principles made by the President on assumption of office. So this was a challenge which had been thrown at the government and its use of the Preventive Detention Act to detain Bafo Akoto and the other people. Now, as you recall, if you look at Article 13 of the Constitution, which the appellant in Re Bafo Akoto had actually complained of, it was to the effect that, quote, immediately after his assumption of office, the president shall make the following solemn declaration before the people. Quote, on accepting the call of the people to the high office of the president of Ghana, I, of course, Dr. Kwame Nkrumah is also, solemnly declare my adherence to the following fundamental principles. That the powers of government spring from the will of the people and should be exercised in accordance therewith. That freedom and justice should be honored and maintained. That no person should suffer discrimination on ground of sex, race, tribe, religion, or political belief. That subject to such restriction as may be necessary for preserving public order, morality, or health, no person should be deprived of freedom of religion or speech, the right to move and assemble without hindrance, or of the right of access to courts of law, and that no person should be deprived of his property, save where the public interest so requires and the law so provides. So these were the various guarantees or assurances which the president was supposed to have made under Article 13, Clause 1 of the Constitution. When he was being ushered or sworn into office, he made those solemn declarations. Now, the courts took the view that the declaration by the president on assumption of office was similar to the coronation oath of the British monarch. And for that matter, such a declaration did not constitute a Bill of Rights, enforceable, if you like, human rights regime, and did not create legal obligations enforceable in the court of law. And the court will go on to say that these were something which was subject to political accountability. If you go to next election and you don't like the president, then that is fine. You can vote against him. And this is how the court rendered itself, and I quote, we do not accept the view that Parliament is competent to pass a Preventive Detention Act in wartime only, and not in time of peace. The authority of Parliament, excuse me, the authority of Parliament to pass laws is derived from the same source, the Constitution. And if by it, Parliament can pass laws to detain persons in wartime, there is no reason why the same Parliament cannot exercise the same powers to enact laws to prevent any person from acting in a manner prejudicial to the security of the state in peacetime. It is not only in Ghana that detention acts have been passed in peacetime, unquote. So, ostensibly, the Supreme Court was trying to justify the propriety of the usage of Preventive Detention Act and the Preventive Detention Orders made thereunder. So if we look at the logic of it, upon reflection, based upon our appreciation of human rights and rule of law now, you may consider it a bit laughable. So as the Supreme Court was saying that, yes, if we agree that if Ghana is at war, then Parliament has powers to make certain laws so as to safeguard the security, then they don't see anything wrong. If there is no war, we are in a peacetime, and Parliament makes a law to check conduct or behavior which may threaten the security of the state. The court thought that that was quite normal, so there was nothing wrong with the Preventive Detention Act in peacetime. Now, regarding effect of Article 13, Clause 1, now if you look at the submission of J.B. Duncan, if you go and read the extensive submission, this is how the Supreme Court reacted to the effects of the Article 13, Clause 1. That is, those declarations, solemn declarations that the president was supposed to make upon assumption of office. So this is how the Supreme Court in Akoto rendered itself. And I quote, "This contention, however, is based on a misconception of the intent, purpose, and effect of Article 13(1), the provisions of which are, in our view, similar to the coronation oath taken by the Queen of England during the coronation service. In the one case, the president is required to make a solemn declaration. In the other, the Queen is required to take a solemn oath. Neither the oath nor the declaration can be said to have a statutory effect of an enactment of Parliament. The suggestion that the declaration made by the President on assumption of office constitute a Bill of Rights in the sense which the expression is understood under the Constitution of the United States of America is therefore untenable. In our view, the declaration merely represents the goal which every president must pledge himself to attempt to achieve. The declarations, however, impose on every president a moral obligation and provide a political yardstick by which the conduct of the head of state can be measured by the electorate. The people's remedy from any departure from the principles of the declaration is through the use of the ballot box and not through the courts, unquote. So the court was trying to say that all the various declarations the president will make upon assuming office in terms of Article 13, Clause 1 of the 19th Constitution, they are good, but they should not be understood as creating justiciable rights, enforceable rights. Rather, if you feel disappointed by the president, when you have the opportunity to vote at the next election, you may want to vote against him. But you couldn't go to court and say that by doing this or by omitting to do that, you have violated my rights, which you solemnly declared to uphold and protect upon assumption of office. The Supreme Court in Akoto said no, that was not how it should be understood. And that is why commentators and scholars who say that Akoto represent one of the most significant and monumental low moments in the life of our Supreme Court vis-a-vis our quest for rule of law, constitutionalism. Now, how the Supreme Court interpreted Article 13 clause 1 of the 1960 Constitution played a crucial role in influencing our subsequent constitution. In fact, if you take, of course, there was a coup d'etat, as you know, there's a military rule from 1966 to 1969. When we had our Second Republic, we adopted the 1969 Constitution. Now, if you look at that Constitution, you will notice that we provided a compendium or dedicated chapter of our Constitution on fundamental human rights and freedoms. And if you look at our current Constitution too, we have done the same thing. 1979 too, the same thing was done. So current Constitution, we have a whole chapter 5, the fundamental freedoms and human rights. And you notice that they embody, in addition to other things, all the things which the president under the 1960 Constitution will have solemnly declared to uphold and protect. So unlike what the Supreme Court would like us to believe with respect to Article 13.1 regarding the solemn declaration by the president that they constitute nothing more than moral obligation, and our current constitutional dispensation, they constitute enforceable human rights. And in fact, the framers of the Constitution were quite careful, and they were at pains to leave no one in doubt regarding the justiciability, enforceability of the compendium of human rights, which they had enshrined as per chapter 5 of their constitutional tablets. And that is why in Article 12, clause 1, the framers of the Constitution will state, and I quote, "The fundamental human rights and freedoms enshrined in this chapter shall be respected and upheld by the executive, legislature, and judiciary, and all other organs of government and its agencies, and where applicable to them, by all natural and legal persons in Ghana, and shall be enforceable by the courts as provided for in this Constitution." So, Article 12, clause 1 of the 1982 Constitution is telling us that the fundamental human rights and freedoms enshrined in Chapter 6 are enforceable. They are binding upon all executive, legislature, judiciary, artificial and natural persons, so long as applicable to them. And it will go to the extent of telling us in Article 33, to tell us in Article 33, clause 1, that where a person alleges that a provision of this Constitution or on the fundamental human rights and freedoms has been, or is being, or is likely to contravene in relation to him, then without prejudice to any other action that is lawfully available, that person may apply to the High Court for redress. And then if you go to clause 2 of Article 33, it will provide the tools which may be used in seeking redress or remedy for alleged violation of human rights, including habeas corpus, certiorari, mandamus, prohibition, quo warranto, and other appropriate remedies. So you notice that in Re Akoto, the habeas corpus was refused by the High Court, and the Supreme Court to say that yes, it was justifiably refused because the right which it was supposed to assert was just a moral obligation, which the president may live up to or not live up to. And the affected citizen may have the remedy in the ballot box. Now, we have moved away from that. So if we look at the 1969 Constitution, we learned our lessons from the failures of the 1960 Constitution as far as constitutionalism is concerned, as well as the quest to establish a governmental system which is limited, which is subject to accountability is concerned. So, as we have indicated, the 1969 Constitution will say that the Constitution is the supreme law of the land. So the doctrine of supremacy, which we have in our current Constitution, went back to the 1969 Constitution. It was there before we came to replicate it now. And again, there was a whole elaborate regime of fundamental human rights, as we have indicated. And also, the president of Ghana could not leave Ghana without consent of parliament. So just to tell you how restraint or limitations are imposed on those who wield various levels of political authority. Yes, there was also a special arrangement for removal of president, including a judicial tribunal which will be set up. Now, when it comes to appointment and promotion of holders of certain public bodies, it was not just done by the president, as was the case in under the 1960 Constitution. At the 1969 Constitution, such appointments were supposed to be made in consultation with the Council of State, as it were. The 1969 Constitution also created the office of the Ombudsman, equivalent of what we now call Commission on Human Rights and Administrative Justice, as it were. And the Ombudsman was supposed to review administrative actions. So what we have under Article 23 of our Constitution now, administrative justice, was the remit of the Ombudsman. Now, same role is played by the Commission on Human Rights and Administrative Justice, or SHAD. Public lands were vested in the president in trust for the people of Ghana. And again, discretionary power was also qualified. If we look at the Constitution, discretionary power under the 1969 Constitution will have been explained to mean the duty to act fairly and also candidly. So when it comes to appointment, yes, once you have the power to appoint, you can also have the power to do what? To disappoint. And again, the only problem which we have was that, because the framers of the Constitution were careful not to open the Pandora box. We have had NLC, National Liberation Council, which overthrew Nkrumah's regime, and through whose compromises we eventually had the 1969 Constitution. So there was a gentle transitional deal that the courts, powers had been ousted with respect to entertaining complaints against the rule or the regime of the National Liberation Council. But as you remember the case of Salah versus Attorney General, the Apollo 568, when the Presidential Commission actually invoked Section 7 of the transitional provisions of the 1969 Constitution to lay off so many people that they deem either not being competent or not being very good people to hold those offices. Mr. Salah, the manager of the, the GNTs, as you remember, went to court. And eventually, the court vindicated him. And later on, the Prime Minister at the time, Professor Abrafe Buzia, was not happy about it and had a dawn broadcast in which he castigated the courts for trying to come out with a decision like that. And that is also seen as a dark spot on constitutionalism as far as the 1969 Constitution is concerned. Now, there were some cases which came up post 1969 Constitution, and they'll give us some insights into how we're faring as far as constitutionalism is concerned. So if we take the case of Shalabi against the Attorney General, for example, it concerned the citizenship of Shalabi. And Shalabi gained his Ghanaian citizenship through the National Liberation Council Decree 191, which subsequently we had the 1969 amendments, and it sought to take away certain rights of citizenship which had been acquired in 1967. And the National Liberation Council decree, then as a decree, used a drafting device, what we call a deeming. So they said that that decree, which had been made by them, was deemed to have come into effect in 1967. As a matter of fact, it was gazetted in 1969, but they gave it retroactive or retrospective effect. That despite the fact that it's today that we are gazetting this law, we deem, or we are presuming, or we are giving effect to it. We are treating it as if it had come into effect the last 2 years. So that was what the NLC decree, which sought to take away certain right of citizenship, which had been acquired in 1967, actually sought to do. Now, eventually, when the court had to determine the challenge by Shalabi to the authority of the state to take away his citizenship rights, among other things, the judge will make the point that the 1960 Constitution merely suspended and the National Liberation Council cannot have more powers greater than the people. So that was quite bold. High Court judge being very insistent on the fact that, yes, if you're government, it doesn't mean that you're unlimited. Now, the main point which the court was dealing with was whether the National Liberation Council, acting as a legislature, because mind you, when the coup is held, they disband the parliament or legislature, and then the coup makers, through their council, will constitute themselves into the lawmaking authority, among other things. So, the National Liberation Council, as a legislature or lawmaking authority, so to speak, they did have unlimited powers. Was it omnipotent? Meaning that it can make a law and let the law come into effect whatever time that it deems fit. So they can say that, yes, we made a law today, but we are saying that that law is deemed to have come into effect 10 years ago, meaning that matters which took place 10 years ago will still be considered as being subject to the regulatory effect of the law, which you have made today. Could it really do that? So that was the crux of the matter as far as the Shalabi litigation was concerned. Of course, certainly the court will take the view that that was not it, that the National Liberation Council, despite the fact that it had become the lawmaking authority, they don't have omnipotent powers, as it were. And we even take the view that, properly understood, the National Liberation Council, if you look at the various statements they made when they overthrew the constitutionally elected government of Kwame Nkrumah in the CPP, they had indicated that they were seeking to re-establish the rule of law in Ghana. And if that is so, then the National Liberation Council had to be guided by its own proclamation. That is the proclamation instrument that it made upon staging of the coup d'etat. And if that is so, how could the NRC as lawmaker amend that which did not exist? Laws or rights that you are saying you've made a law now and those are deemed to have been taken away. They did not exist at the time. So how can you make a law to apply to things which were not? So therefore, the legislation cannot purport to affect or operate to the detriment of persons who had acquired citizenship rights before the coming into force of the 1969 Constitution. And you also know the case of the Captain versus the Attorney General, a similar challenge. The plaintiff, Mr. Captain, Omar Captain, was a Lebanese national and brought an action against the Minister of Interior in connection with revocation of his residence permit by the minister. Now, Sections 7 and 8 of the Aliens Compliance Act permitted the revocation of a residence permit by a minister. Now, if you remember, in terms of politics, one of the things that opponents of the Danko Buzia tradition used to taunt them or flag their face was what they call the Aliens Compliance Order. Of course, modern day, what Donald Trump is also seeking to do in the US, that if you are illegal immigrant, we are going to send you back to your country. I mean, this is really not new. You hear it about the United States and you think it's something new. It's not new. Even in our country, way back in 1969, we had the Aliens Compliance Order, which had a similar effect to some of the things that the US is seeking to do under the removal of undocumented immigrant, as it were. So the question which had to be dealt with by the court was whether or not the revocation of the residence permit of Mr. Kaftan by the Minister of Interior violated his fundamental human rights, and whether the minister was required to act under Article 173 in taking the decision to expel the plaintiff. Now, Article 173 of the 1969 Constitution is in pari materia with Article 296 of the 1992 Constitution. In law, when we say that something is in pari materia, what it means is that it's similarly worded, or it has like the similar substance of something. So the Article 173 of 1969 Constitution is in pari materia with the Article 296 of the 1992 Constitution. And if you look at Article 296, you notice that it regulates the exercise of discretionary power. And among other things, we say that exercise of discretionary power shall be deemed to imply a duty to be fair and candid. It shall not be exercised arbitrarily, capriciously, or based upon bias. And that if you are not a judicial officer or holding judicial authority, you are supposed to come out with predetermined rules which will govern how you are going to exercise the discretionary power. So that's essentially what we have in Article 296 of the current Constitution. And same provision existed under Article 173 of the 1969 Constitution. So Mr. Kaftan brought a case against the Minister of Interior challenging the revocation of his residence permit and saying that the power of the minister to revoke his residence permit should it not be subjected to the framework which controls exercise of discretionary power, in this case, Article 173 of the 1969 Constitution. Well, it was held that the minister, in expelling an alien under Section 7 and 8 of the Aliens Compliance Act, does not exercise such a discretionary power as falls within the purview of Article 173. And for that matter, he is not obliged to assign reasons. Now, if you take the view that the power of the minister to revoke residence permits was a discretionary power, and for that matter, amenable to the controlling framework of Article 173, then what it meant was that the minister could not just revoke the residence permit at will. He needed to assign reasons. The reasons themselves could be gone into or could be tested to find out whether they were meritorious or unmeritorious. And the court held further that the Constitution itself does not confer any such powers, and that it was only in cases where the exercise of administrative or executive power involves an inquiry of a judicial or quasi-judicial nature can the provisions of Article 173 be invoked. So if you look at it, the court was trying to limit what counts as discretionary power. The court was saying that yes, if there is discretionary power cognizable under the Constitution at all, it should be in relation to those who are doing investigation or activities that pass as judicial or quasi-judicial. They will have to be amenable to the controlling framework of Article 173 vis-a-vis discretionary power. But as you notice, if you read the Committee of Experts report and you read the proceedings of the Consultative Assembly, which culminated in the 1992 Constitution, you will understand how and why the Article 296 of the 1992 Constitution, which we have said is largely impera materia with Article 173 of the 1969 Constitution, has been worded the way that it is. So we will briefly look at how we fared as far as constitutionalism is concerned anytime we had the military taking over the governance machinery of the country. And on this, we would like to drink from the streams of lectures, public lecture, which Professor Kumado provided some time ago on a very beautiful theme, Constitutionalism, Civil Liberties and Development, a case study of Ghana since independence. Now, in this public lecture, I have shared the original text of the lecture with you last week on your platform. So I presume that you have read the text of the public lecture which Professor Kumado did. So I'll just give you a highlight of his discussion. So in this lecture, Professor Kumado discusses the role of military regimes in Ghana's constitutional history. And he sought to examine how military interventions have impacted constitutional governance and civil liberties. So that is the crux or the burden of his argument. And we decided to look at a few sessions of his public lecture. So he looked at how military rule is seen as a reaction to civilian government failures. So he tries to make the argument that if you look at military coups in Ghana, when they are staged, the coup makers and their sponsors would try and present the coup as a response to failures of civilian regimes, that civilian regimes, they have failed in exercising the confidence which the public have reposed in them. And often, the coup makers will accuse the civilian regime of corruption, incompetence, and failing to address socioeconomic issues. So if you are to look at all the coups which have taken place in our country since 1966, and you are to examine the rhetoric, the narrative, which are presented by the coup makers or their spokespersons, you notice that these are the reasons which are often canvassed to justify such unacceptable intervention in constitutional democracy. And Professor Kumado reminds us that the military regimes, they often claim to act as caretakers of the state, and that they will provide justification or intervention as necessary to restore order and stability, where civilian governments have fought that wanted to prevent the country from actually degenerating. So we took over the wheel of governance in order to restore order and prevent abyss, prevent chaos from being unleashed in the country. That is why you see the coup. So that is often the rhetoric of the coup makers. And that is the point Professor Kumado canvassed, and that is well received public lecture. Constitutionalism, Civil Liberties and Development, case study of Ghana since independence. Another point which he canvassed is that military rule, by their nature or inherently, disrupts constitutional governance by suspending or abrogating the Constitution. In fact, military rule is incompatible with constitutional or with the Constitution. The Constitution cannot remain in force and at the same time have a military rule. Or somebody said, you cannot live in Sodom and Gomorrah and seek the title, the virgin, so to speak. The two are incompatible. So, following the 1966 coup, which our state president, Kwame Nkrumah, we had the National Liberation Council, NLC. It dissolved the existing constitutional structure and sidelined democratic and judicial checks on governmental power, so to speak. And when we have military regimes, they try to consolidate their power through decrees. So military regimes, they actually recognize the importance of law. And they will try, except that this time they are issuing the law. But they recognize the usefulness of the law as a tool, as an instrument of governance. And they often also sideline the judicial system or the legislative process, or even for the judicial system, if they will tolerate it at all, so long as the courts are aligned with the philosophy of the military government and not question them, as it were. There have been various attempts to legitimize military rule, and Professor Kumado in his lecture canvasses that point as well. And how did they do that? That when they do the coup, they will create what you call the proclamation. They'll create a proclamation, and the proclamation is supposed to be if you like, some sort like a constitutional, if you like, a document or instrument which provides legitimacy for the authority of the military government, except that it concentrates power in the hands of the military rulers. Now, despite the attempt to give a semblance of constitutional legitimacy to military adventurism, they don't succeed. Particularly, there will be no genuine checks and balances. In absence of checks and balances, Professor Kumado says that what we are effectively left with is one-man rule, where ultimate power was centralized, and that undermined any serious understanding or any rare notion of constitutionalism. Now, how do military regimes impact on civil liberties? Undoubtedly, when we have military governments, they curtail civil liberties, particularly freedom of speech. You cannot just say anything you want just like that. Media freedom and so on. So if you are to know, until President Kufuor's led NPP administration of 2000 to 2008 came to repeal what was known as the seditious libel law. There was a provision in our Criminal Offences Act which made it offense for you to publish anything which was defamatory of the government. It was a criminal offense of people who exercise governmental authority. Now, that law was used very well by our military regimes, and so many people were actually convicted and imprisoned. And not only freedom of speech, association. When there's a military regime, you cannot form political parties. No. Because political parties seek to mobilize to capture political power. And these military leaders are exercising no political power. So why do you want to capture it again? So associations are not allowed. There's no right to due process. So there's the so-called fair right, fair trial rules we know in Article 19 of the Constitution, for example, are not respected during military rule. And they will make preventive detention decrease and say that people whose conduct are considered prejudicial or inimical to the security of the state will be arrested and detained as it were. So the point Professor Kumado makes in that public lecture I'm recounting for you is that when there's a military rule, civil liberties are secondary to the military's objective of political and economic stability. So for them, what matters to them is that there will be political and economic stability, and other civil liberties are not really important, or if they're important at all, they are a secondary matter. And don't forget that civil liberties are the very important reflection or the mirror constitutionalism. After all, what is the point about constitutionalism? To place restraints on those who wield governmental authority so that there will not be arbitrarily interference with the rights and freedoms of the citizen. So if you reflect on military regimes since our independence to date, Professor Kumado will tell us that despite the fact that these military regimes claim to restore or protect the Constitution. The actions often contradicted this intent. And you can cite so many examples. Democratic institutions are suspended. There's no judicial oversight. And in fact, without judicial oversight, that would be a serious contradiction to the core principles of what? Of constitutionalism. What are the courts there for? The courts are there to ensure that those who exercise various aspects of governance, they stay within their remit, so as to safeguard the liberty and freedom of the governed. And that is why he will make the point that military regimes repeatedly illustrated the paradox, the contradiction we're talking about, by invoking constitutional values, while at the same time undermining the very structures that uphold constitutionalism. So there are a number of interesting cases or case law during the military regime, which Ghana has experienced, that illustrate how constitutionalism was relegated to the background. So you may want, you must read and brief the case of state against the general officer commanding the Ghana Army, ex parte Brima, 1967, Ghana Report 192. Republic against Chairman, Commission of Inquiry, State Fishing Corporation, ex parte Bannerman. The two Salifa cases. With the two Salifa cases, if you get the 2GNJ, that is the special compilation of the early constitutional cases by Professor Jando and Griffith. You find them there. Or you can read them in the 1968 Ghana Law Report. That Republic against the Director of Prison, ex parte Salifa. So please read and brief them. Also look at the case of Shalby against the Attorney General, then the Fatah against the Minister of Interior. We'll just give a brief discussion of some of these cases, and then we will move on. So if you take ex parte Brima, for example, we had a Nigerian resident in Ghana called Yusuf Itareba Aminu. He was arrested 3rd January 1967 by the army authorities under NLC Decree 109. And what was the reason? He was arrested on suspicion of having committed offense of stealing. So let's look at the chronology. On 4th January 1967, the following day, the Attorney General gave his consent in writing for the detention of the respondent for a period of 28 days, beginning from 4th January 1967. The period of 28 days expired on 1st February 1967. And on that day, the Attorney General issued another consent in writing for the detention of the respondent for a further period of 28 days. As from 1st February 1967. Now let's look at the chronology. So another round of 28 days, starting from 1st February 1967. On 7th February 1967, the respondent, by his nephew, Yahya Aminu Brima, and that is why the case is ex parte Brima, applied to the High Court for writ of habeas corpus. No prerogative orders are issued against the the state or agencies of the state. And then the person who is looking for them, he's the one, he's the applicant. So we say the ex parte something. So ex parte Brimer. So Brimer was the applicant. So apply to the High Court for writ of habeas corpus for the release of the respondent from custody on the ground that the Attorney General had no power to give consent once the respondent had completed the original 28 days in custody for the further detention of the respondent. So the respondent's case, therefore, was that his detention, as from 1st February 1967, was unlawful. Now, the case came before Justice Antechi. Justice Antechi, sitting in the High Court, accepted the respondent's view of the law and ordered his release. Now, he held, among other things, that the Attorney General had the right to issue further written consent for detention of suspected person following the expiration of original 28-day period of detention. Section 10, subsection 1 and subsection 2 of the Interpretation Act, mind you, this has been repealed by the 2009 Interpretation Act, overcame the inconvenience that was formerly caused by the doctrine that a statutory power was exhausted by its first exercise. So the court was also satisfied that the inquiry into the matters relating to the arrest and detention of Aminu for an offense against the ordinary criminal law was complex enough to require for its completion a longer time than 28 days. And for that matter, it was not safe for Aminu to be at large while the inquiries were being conducted. So please read the case of ex parte Brimer. Also look at the case of ex parte Bannerman. Now in ex parte Bannerman, on 18 January 1967, the military regime, National Liberation Council, by virtue of provision from the Commission of Inquiry Act, appointed a Commission of Inquiry to inquire into a matter in relation to State Fishing Corporation. The applicant, Mr. Bannerman, was a distributing marketing manager of State Fishing Corporation. During the course of the inquiry, the commission reported to suspend Mr. Bannerman from his position. And they sent him this letter. No suspension. With immediate effect, you are being relieved of your duties and responsibility as distribution marketing manager in State Fishing Corporation. You are to hand over immediately to your most senior subordinate and advise the chief accountant and the production manager. So this letter was sent to Mr. Bannerman. So when Mr. Bannerman came to court, he sought certiorari to have the decision or the letter of the Commission of Inquiry quashed, and also sought prohibition to prevent the chairman or the commission from suspending, dismissing, interdicting, or in any such manner interfering with Mr. Bannerman in the performance of his duties as distribution manager of State Fishing Corporation. Now, the allegation which prompted Mr. Bannerman's reported suspension was that between 1964 and 65, over 1,100 cartons of fish have been stolen by him in collusion with one Kwe. So this was the allegation. The court granted the reliefs which Mr. Bannerman sought, and to a large extent, the court said that Mr. Bannerman has suffered a violation of his right to natural justice, especially the rule of audio oteram partem, that you should hear both sides of a matter before you decide. The other rule of natural justice is nemo iudice in causa sua, and no one shall be a judge in his own cause. But here, what was implicated was the alteram partem, that you should hear both sides of a matter. You must grant a person hearing before you reach a decision. So this is how the court rendered itself. Quote, the applicant by his suspension will be deprived of at least part of his emoluments, which deprivation is in the nature of a penalty. And for such punishment to be noted against him, without a hearing of his side of the story, militates against even good conscience. The consequence, in my view, is that there was an abnegation of judicial duties involved in the function of the Commission of Inquiry, or its chairman, the result that the decision must be regarded as of no effect and invalid. And it will go on and make the point that he was entitled to be given the hearing. So go and read the full judgment and then brief it, as I have told you. Also, with respect to the Republic against the Director of Prisoners Party, Salifa, we had a 15-year-old boy who had been sent to Guinea by his father to continue with education somewhere in 1965. While he was there, it was alleged that he ran away from his guardian, the person who was looking after him, because the person who was looking after him was maltreating him. So he ran away to Sierra Leone in 1967. And he sought assistance of Ghana High Commission for his return. Upon his arrival in Ghana, the police arrested and detained him. And subsequently, his father filed an ex parte application for an order of habeas corpus on the grounds that his son's detention was unlawful. The Director of Prisons sought to justify the detention by filing a copy of a document purporting to be a decree signed by the chairman of the National Liberation Council, which had authorized the arrest and detention of Salifa. Meanwhile, the document was neither published in the Gazette, nor was it given any number, as was required by the National Liberation Council Establishment Proclamation. But they had indicated that, yes, the decrees will be given numbers, the decrees will be gazetted. But none of this was done as far as this particular decree was concerned. So the issue presented to the court was the validity of the decree in question. Was this decree valid? The Director of Public Prosecution put out the argument that since the decree had been signed by the National Liberation Council chairman, its authenticity could not be questioned in court, notwithstanding the alleged defect. That is the fact that it had not been published in the Gazette, the fact that it had not been given a number, as is usually done with decrees. So this was the argument the state, or presented on behalf of the state by the Director of Public Prosecution. And they stress further that by virtue of the establishment proclamation, the National Liberation Council had unlimited power, and by necessary implication, the legality of its decree could not be questioned. So this was a lawyer working at the Attorney General Department under military regime, using his knowledge of the rule of the law to try and justify actions of the military regime. Now, the trial judge, Justice Antechi, disagreed with this position of the law canvassed by the Director of Public Prosecution and pointed out that the issue was not whether the decree having the same status as an act was in excess of the powers of the enacting authority, but whether it was an act at all. The learned judge held that since the decree in question had not been published or numbered in accordance with the very proclamation, that established National Liberation Council, it was invalid. And for that matter, an arrest and detention arising under it was also unlawful. So Antachide made the point that the National Liberation Council could not purport to have unlimited powers. Now, this is quite poignant because we have a military regime, and the court is having the audacity to hold the military government to significant level of what? Constitutionalism. According to the learned judge, such a position will be untenable as it will be inconsistent with the very existence of the National Liberation Council. The National Liberation Council, you issued a proclamation, establishment proclamation, and in that you stated that this is how decrees will be made. But you have acted contrary to your own establishment proclamation. And this is how the judge rendered himself regarding this particular aspect. Quote, the proclamation provides for the eradication by the National Liberation Council of illimitability of power in Ghana. Mind you, Nkrumah and the CPP had turned themselves into omnipotent. They turned themselves as holding power, which was without limit. So this was reference to that. So the proclamation provides for the eradication by the National Liberation Council of illimitability of power in Ghana. And I therefore dismiss eliminate the last argument of the learned principal state attorney that the National Liberation Council have, by the proclamation, an unlimited power. With due deference to the learned principal state attorney, that argument commands no weight, for autocracy in Ghana was given a decent burial on 24 February 1966, unquote. So, despite the fact that the National Liberation Council was a military regime, the judge was trying to say that we must look at the history of your coming into power. You have staged the coup because the civilian administration at the time had turned itself into autocracy. And if that is so, then you had come to right that wrong. And for that matter, you could not be seen to be assuming illimitable authority or power. And the judge continued, in the result, I do find that the cell prisoner, Muhammad Abdul Rahim Baba Salifa, undeniably described in Exhibit A to the return as Muhammad Abdurrahmi alias Baba Alaji, has been and is being unlawfully detained, not because the authorities have no discretionary power to detain him, but because such discretionary power has been exercised in detaining him in a manner otherwise than is lawfully permitted under the provisions of the law, as laid down by the Act of Parliament, namely the proclamation. And I therefore do order that the said prisoner be discharged forthwith. So please read the ex parte Salifa and look at the second Salifa case as well. Because immediately after his release by Antachide, Salifa was rearrested without warrant and was detained for suspected subversion and another unnumbered and unpublished National Liberation Council decree. We could see that the military government was really on Mr. Salifa. Mr. Salifa's father filed another application for writ of habeas corpus for the immediate release of his son on the grounds, among other things, that the rearrest without warrant was unlawful, and further that the subsequent unnumbered and unpublished decree was also invalid. I'm teaching according. Okay. I am teaching according. Yeah, so please read the full case. I have put enough material from that case in the slide for you. So look at that. Yeah, so just before we draw the curtain down on discussion of constitutionalism, we would like to look at constitutionalism under our current constitution, the 1992 Constitution. And for that aspect of the discussion, I invite you to read the very interesting and compelling discussion which the highly venerable erudite scholar Nana Dr. Susubirbi Krobia Asante, Nana SKB Asante, who was the chairman of the Committee of Experts, whose work provided the basis for discussion by the National Consultative Assembly, leading to the 1992 Constitution. He did a very interesting public lecture as part of the J.B. Duncan Memorial Public Lectures. And he chose to reflect on the Constitution, law, and development. So, as part of that 3 days public lecture, which Nana SKB Asante did, he also reflected on constitutionalism, and he identified objectives of constitutionalism under the 1992 Constitution to encapsulate the following: 1, prevent executive overreach and ensure accountable governance. 2, promote the rule of law by embedding checks and balances within the governmental structure. 3, uphold fundamental rights and freedoms for citizens. 4, facilitate development within a stable democratic framework. So these are what the architects of the technical proposals, which culminated in the adoption of our current constitution, identified as the goals of constitutionalism as deployed in the 1992 constitutional tablet. So he reflected on the role of the executive in our constitution and the various limitations which are imposed on the executive. So with respect to structure of executive power, he makes the points that the Constitution vests executive power in the president, and we have discussed this before in the class. If you look at Article 58 of the Constitution, it's quite there. It's quite explicit that the executive authority shall be vested in the president. And that has granted significant authority to govern effectively. There's no doubt about that. The president is assisted by the cabinet. And despite the fact that executive authority is vested in the president, the Constitution mandatorily directs or enjoins the president to have a cabinet, which will advise the president on national policy. Now, that notwithstanding, the cabinet does not constitute collective executive power. The executive power, the executive authority, is ultimately vested in the president. And that is the import. That is the effect of Article 58 of the 1992 Constitution. So let us keep that in mind. So the fact that the president is supposed to have cabinet ministers, if you look at Article 76 of the Constitution, which says that there shall be a cabinet which shall consist of the president, the vice president, and not less than 10, and not more than 90 ministers of state. Then 70 says to, the cabinet shall assist the president in the determination of general policy of government. So, Article 58 vests executive authority in the president, but at the same time, the president is not supposed to just act alone. The president needs to be assisted, needs to be advised by a constitutional body known as the cabinet. With respect to the scope or the spectrum of executive authority, he notes that the president's powers include appointment of ministers, as we know, appointment of ministers. If we look at the Article 78, Article 78, 79 of the Constitution, appointments of heads of a public institution, military officers, and the judiciary, often in consultation with or subject to the approval of other bodies, the Parliament and the Council of State. And you remember the case of J.H. Mensah versus what? Attorney General. The duty to get a prior approval or the obligation to get prior approval of Parliament where we can appoint ministers. The president is only the commander-in-chief of the armed forces. He's the head of foreign policy and has authority to sign or veto legislation, as we see under Article 106 of the Constitution. Now, that notwithstanding, there are checks on the presidential powers. For example, when it comes to appointments, let's say certain key appointments like appointment of justices to the Supreme Court and the Chief Justice, as well as appointment of ministers of state. The president alone cannot appoint them. He requires parliamentary or Council of State approval or advice. And that introduces accountability with respect to the presidential powers on appointments. There's also another check in the form of judicial review. The judiciary has the power to review executive actions to ensure that they comply with the Constitution. And there are many landmark rulings which have overturned executive decisions which contravene the constitutional right. So many of them, can name them. Well, many scholars, including Nana S.K.B. Asante, hold the view that some aspects of the Constitution give excessive powers to the president, and that has the potential to undermine the separation of powers. Next week, we'll be discussing separation of powers, and you'll notice that is another important pillar of the architecture of constitutionalism. But they have pointed to the power of patronage. The president can appoint many governmental officials and board members, and that can lead to executive dominance, particularly so if there is no counterbalance from effective parliamentary and judicial oversight. People want appointments and positions. Now, just drawing analogy with the US, where some of the media houses are jovially referring to the president-elect, President Donald Trump's private residence by Mar-a-Lago, I think somewhere in Florida, as a center of pilgrimage, which is flogged or visited by people who are desperate to get one appointment or another in his incoming administration. I mean, the same thing applies here. As soon as in a few weeks we are going to have our election, whether President Baumia or President John Mahama or President Sheda or Apalo, as soon as the results are declared, you will notice that people will start gravitating towards the winner in order to court attention and get some appointments. So that is the power of patronage they're talking about. Well, he also identified parliamentary oversight and legislative function. So Parliament has got a role in constitutionalism. In what ways? Parliament acts as a crucial check on the executive by holding it accountable, passing legislation and approving budgets. If we look at 103 of the Constitution, for example, yes, the president has executive authority, but you cannot govern without money. You need to make proposals regarding what you need to spend money on and so on. Now, if you look at Article 103 of the Constitution, for example, you will notice that there are various committees, right? Various committees in Parliament. And the various committees, they have the mandate to exercise direct and indirect oversight over how the executive functions. So we have various investigative committees which conduct inquiries into various executive action. You take the public accounts committee, for example. Every state institution will appear before it when the Auditor General report has been published. But parliamentary oversight, an important aspect of constitutionalism, according to Nana Dr. S.K.B. Asante in his public lecture, is not without challenges, particularly so when it comes to resource and expertise limitations. If you take MPs, for example, we don't have strict requirements in terms of qualification of the competencies or the expertise you have before you stand to be elected as a member of parliament. And that in itself can reduce capacity. There are certain matters which are so technical, require a certain level of intellectual maturity and appreciation. If you are elected MP, but you lack certain reasonable level of competency, it will definitely impede your capacity to exercise effective oversight. Another challenge has to do with the lack of legislative autonomy. If you look at Article 108 of the Constitution, for example, it is seen as a big problem because in Article 108, we are told that when it comes to law or bills having financial implication, if you intend to initiate any bill which will become a law, that will have any financial obligation on the state, it must be introduced by the executive or with the executive consent. And that in itself limits independence of parliament, meaning that parliament on its own cannot initiate any important bill which has financial implication on the state unless the executive has given its approval. So look at 108 of the Constitution. Another problem which Now Dr. SKB Asante discussed in his that important public lecture, JB Dankwa public lecture, has to do with the member of parliament appointment requirement. And if you look at the constitution, majority of ministers are supposed to be appointed from parliament. And that has bled the separation of powers. We don't have what we call the bicephalous executive. We have monocephalous executive. We have presidential system of government, not parliamentary system. And yet, our constitution says that majority of ministers should come from what? From parliament. And that is quite worrying. That is quite worrying because if parliament has various committees which is supposed to subject executive actions to accountability. Now, these ministers are part of the executive and they're also in parliament. So how effective can the parliamentary scrutiny be? They serve on various committees with their colleague MPs who are not ministers. They are friends, they share goodies, they share benefits. So how can you have effective oversight? So I think that there's a merit in that criticism, which Nana identified in that public lecture. So to ameliorate some of this problem, he recommended that parliaments should be strengthened through dedicated legal and policy analysis units. Maybe there should be effective, maybe legal units, policy analysis units within parliament establishment, which provide the technical support for members of parliament so as to enhance their oversight capabilities. Nana SKB Asante further suggests that we should consider a review of Article 108 of the Constitution. Now, Article 108 is a provision which says that when it comes to financial settlement, any bill relating to financial settlement, it must come from the executive or must have the blessing of the executive. So he is saying that we need to rethink, we need to reform, recalibrate that particular provision so as to enable Parliament to exercise greater autonomy in physical matters. And finally, he touched on the role of the judiciary in constitutionalism. And in that respect, he cited Article 125 of the Constitution, which was about judicial independence, among other things, and empowers the judiciary to uphold the rule of law, and that as a safeguard against the executive and the legislative overreach in our polity. Now, judicial appointments, as we have noted, require consultation with approval from the Council of State, especially at the Supreme Court or Parliament. And that add a certain layer of scrutiny that, yes, the judiciary itself is also subject to some constitutionalism, some limitations. Now, judicial review is an important constitutional tool for delivering constitutionalism. And as we notice, judicial review allows the judiciary to interpret the Constitution and invalidate laws or executive actions that violate the constitutional principles. And we are living in exciting times, especially when tomorrow the Supreme Court is going to give a major decision as to whether it is the Supreme Court which has the constitutional competence to give authoritative pronouncement on constitutionality, or any organ of state which is also working on the Constitution can authoritatively pronounced on the Constitution as relates to its work, and that will have the label of finality, or it is a particular organ that has that mandate. So that is important. So you look forward to whatever decision that will come from the Supreme Court. Of course, he also identified the problems which hamper the judiciary and weaken the role of the judiciary in achieving constitutionalism. Resource constraint, and that is one area. We talk about judicial independence, but when it comes to money, when it comes to resources, is the judiciary really independent? I don't think so. The judiciary is not independent in terms of resources, because the judiciary does not get what it wants budget-wise. There's also the potential of executive influence. Yes, there are various structural safeguards, but the fact remains that the judiciary may face indirect pressures due to the president's role in the judicial appointments. So these are matters which we need to confront. So these are some of the ideas which Nana Dr. S.K.B. Asante shared in his public lecture. So how do we balance power through constitutional design? How do we ensure effective constitutionalism through constitutional design? So we have separation of powers and checks and balances. The 1992 Constitution embodies the principle of separation of powers by allocating distinct roles and powers to the executive, the legislature, and the judiciary. So we've seen that. We are going to discuss separation of powers as a full thematic area in our next lecture. Now, checks and balances are implemented to ensure that no single branch of government can dominate, and that in itself upholds the democratic governance. Now, how do we strike a balance between effective national authority and also safeguarding ourselves against authoritarianism? And now Dr. S.K.B. Asante, in his public lecture, registered a caution that while a strong executive is necessary for stability, there must be limits to prevent authoritarianism. The Constitution's emphasis on judicial and parliamentary checks, in his view, reflects Ghana's commitment to a balanced and democratic governance structure. Then he also pointed to the role of fundamental rights. So the fundamental rights, for example, as we have in Chapter 5 of the Constitution, safeguard the citizen from government abuses and ensure that constitutionalism is grounded in respect for human dignity. And we've mentioned Article 12, Clause 1. It's very important. Article 12, Clause 1 of the Constitution makes it mandatory, obligatory for every arm of government, every public agency, institution, and even private, artificial, and natural persons, where appropriate, to uphold fundamental human rights and freedoms. And that is a very important aspect of constitutionalism. So these rights are enforced through judicial oversight. And that in itself reinforces the Constitution's role as a protector of personal freedoms and social justice. So, having said all this, we need to reflect, we need to ponder certain pertinent issues regarding the effectiveness of the Constitution as far as constitutionalism and all the good things we know regarding constitutionalism are concerned. So one, to what extent has the 1992 Constitution succeeded in achieving its goal of promoting democratic governance and protecting rights? So this is something I would like you to think about as we study. Two, can additional reforms enhance effectiveness of Parliament and the judiciary in performing their oversight roles, as we've discussed? Or you think that what we have now in terms of the constitutional design is enough to guarantee effective constitutionalism? Yeah, so all said, the takeaway from an SKB Asante's public lecture I have reviewed with you is that historical experience, what you've been through as a people, should guide any effort to amend our Constitution. In his view, the 1992 Constitution was a response to Ghana's post-independence history of executive dominance, and for that matter, seeks to prevent its recurrence. So we should always be guided by this when we think of amending the Constitution. I wish I could finish this class. Almost done. Yeah, so please, I'd like you to look at the cases like NPV versus the Attorney General, what you call the public order case, read it. NPV against Rollins, the 23rd December case, read it. And then look at the case of Asari against Attorney General, Ajechum against Attorney General in Akoto. Yeah, so I would like to take the questions before we draw the curtain down. We'll discuss discretionary power in detail when we are discussing the rule of law. Yeah, so if you have questions, we will like to take them before we end.